Can you be sued for wholesaling real estate? Hey guys, Rick Ginn here, and in this video, I'm actually going to walk you through the problem of lawsuits pertaining to wholesaling real estate. I'm going to show you what you can possibly be sued for, who's going to sue you, and most importantly, the best ways to protect yourself. And I'm going to share with you some tips and secrets over the last 18 years I've used to avoid any type of lawsuits pertaining to wholesaling real estate. But before I start, do me a favor, hit that like button, hit that subscribe button. You want to keep getting videos like this from myself and Zach. And also, before I get started, I am by no means a lawyer. I'm not here to give you legal advice. I'm just giving you my personal experiences and my opinions. I strongly suggest that you reach out to your real estate lawyer and walk through some of your action plans to protect you against a lawsuit. So let's get into it. What is the real problem? How in the heck can I or you be sued doing a wholesale real estate transaction? Well, the real problem is anybody can sue anybody at any time. So the problem lies in if you get served with a lawsuit, you and me have the burden of defending that lawsuit. No matter how stupid it is, how false it is, it costs money. So the average lawyer bill in the United States is between $400 and $500 per hour. And yes, they bill per hour. So even if you have to get a case dismissed, you're looking at spending $3,000 to $5,000 just to clear the lawsuit. And by the way, if you ever get served a lawsuit, you want to contact the lawyer as soon as possible. Avoiding the lawsuit by not responding to it is the worst thing you can do. So number one, we bear the burden of defending the lawsuit. You have to defend it once it's in there. If you don't defend it, you're going to get an automatic default against you, or what they call a judgment. So let's talk about what we can be sued for in wholesaling real estate. Now, keep in mind, I am not a lawyer, so I'm just giving you my experiences. Based on my experience in 18 years, there's basically three things that you can be sued for. And they're in I'm not doing them by order of importance. Let's just call it relevancy. So number one, breach of contract simply states that one party did not fulfill their obligations in the contract. The reason we enter into a contract is to hold people accountable to make sure they follow through on the agreement. If we did everything by word, everyone would constantly change their minds and it would be really hard to transact in real estate. So all legalities, all lawsuits, any type of potential suing is always going to wrap around your contract. Let's talk about the contract real quick. Make sure you have a contract and you've sat down and reviewed it with your lawyer. I'm going to go a little bit deeper in that towards the middle of this video. So number one, breach of contract. It means one party didn't live up to their end of the expectations. We are going to focus on our expectations. I'm not about going out and suing people. And there's a lot of people that will not fulfill their end of the contract. You have to make that personal decision if you want to sue somebody. I highly recommend it against it unless you've really been hurt financially. So number one, breach of contract. Number two, damages. Yes, you can be sued for damages. If you record something in public record, you caused the seller harm because they couldn't sell the property and they missed out on other buyers, they can hire an attorney to figure out what the damages they are entitled to. And the lawyer's job is to build up a case of the biggest number and ask the courts for financial compensation to the seller, or if it's like a third party or anything like that. So damages are lost. It's basically when they lose money because they entered into a contract with you and you never ever followed through, and it costs them time and money. And keep in mind, damages will also include the lawyer's fees at $400 to $500 an hour. It's something we all have to pay attention to. And the third one is fraud. I guess fraud isn't really technically a lawsuit in itself. It's the merits of a lawsuit. So fraud is basically when you have been exposed or defined by a lawyer that you are doing something basically fake, or it's not real, or you deceived somebody. The key is here, if you get nailed with a fraud charge, the implications are really, really bad. So if you ever got a fraud judgment against you, it's a lot like a student loan. It doesn't go away till the day you die. You can't file bankruptcy. It doesn't expire in 10 years. It's there forever. So nobody likes the word fraud, but what you're going to find out every lawsuit, everyone tries to go, it's fraudulent. You did this, you did that. And I want you to be aware of it. So there's 3 things you can be sued for. Breach of contract. You can be sued for the seller's damages or the third party's damages. And number 3, fraud. Fraud is just a lever used in either one of these 2 types of actions that can really cause you pain. And to take it a level further, fraud can actually turn into a criminal action. So the 2 I talked about earlier, civil. I'm not a lawyer, so I'm not going to go like deep down these holes, but you need to understand these are the 3 things that people will bring up to you when a potential lawsuit comes in regards to wholesaling a piece of real estate. The next thing we need to define is who would be suing us. Well, this is really, really simple. There's only 2 types of people that can sue you. Number 1, your biggest risk is always going to be the seller. The seller is typically going to go after you for breach of contract. An attorney's going to try to turn that into some sort of monetary damages that you lost. Once again, this is going to depend on your contract. And if the realtor finds that you're doing something that is not above board or you're deceiving the seller, they're going to try to turn it into a fraud claim. And remember, if you get labeled a fraud and they can prove it in court, you have all sorts of issues coming your way. So don't worry, I'm going to show you how to avoid this stuff. I've been around 18 years. Yes, I've been sued. I've been sued in wholesaling real estate, and 99% of the time it can be prevented. So that's good news. So don't freak out when you see this video. If you do business above board and you understand the terminology, you will be prepared for it and it won't be a really big deal. So the second person that can sell you can be like a third party. Believe it or not, you can be sued by like a realtor, board of realtors. You can have a vendor, a contractor, or maybe there's another buyer on the property that apparently maybe they have an outstanding contract and they can sue, although they typically have to go over the seller first because if the seller's obligation if they entered under multiple contracts. So there's 3 types of ways you can basically be sued: breach of contract, damages, and fraud. Remember, fraud's just the lever of the 2. I put it in there so you guys can understand it. Who can sue you? Typically, the seller's the one we're going to worry the most about, or a third party. Maybe you brought in a contractor to do some rehab and you got in a dispute over it, then they could possibly sue you. So let's talk about ways to avoid a lawsuit, potentially wholesaling real estate contracts. So number 1, in 18 years, and a lot of this is common sense, guys, is do not lie to your sellers. Let me repeat this. I know you're never going to find this in guru land because they don't teach it out there, is just be honest and tell the truth of what you're doing. You're there solving problems. You sometimes buy them yourself. You sometimes sell them to partners or third parties that you have relationships of high equity net worth to buy the properties. See, the more you tell the truth, you don't have to worry about like navigating through a lie. That old terminology, the truth will set you free, it works in wholesaling. But everyone they spend so much time in wholesaling trying to lie to everyone. Most of your sellers, they don't care what you do with the property. They just want to make sure you can follow through and get it sold for them. It doesn't always mean you buying it. It might be a partner, might be funding it with hard money. It doesn't matter. Just for God's sakes, tell them the truth. So if you're brand new to the business and they got to close the property in 10 days and you don't have any cash buyers with them, you need to heed the warning. You need to find other ways to help them out and not put them in a bad position. So the old term fake it till you make it does not work. That is a recipe to get you a lawsuit in wholesaling real estate. Number 2, fully understand your contract. What do I mean by that? A lot of you guys go out there and get these boilerplate one-page contracts, which I don't really have a problem with them. But I'm going to be honest with you, most of them are pretty untested in the court systems. And remember, just because you put it in a contract does not make it legal. Let me repeat that. Just because you put words on a piece of paper does not make it legal. So what I suggest is take your contract that you're comfortable using, you've had success before, or if you're just starting out, just sit down with a lawyer. They will spend 10, 15 minutes with you and help you out. Even if it costs you $50 or $100, please do it, because they're going to tell you what the pitfalls in your contract and give you recommendations to adjust it. So don't be scared to use your state approved contracts that realtors and lawyers have approved in your state. So that's a place that you can start. There's a ton of language in there. They all boil down to terms, which is going to be price, date, time, deposits, and what happens if you don't follow through on the contract. So you can use that as a fail-safe till you generate some more money to maybe get a lawyer consult. But please, if you download one on the internet, understanding every state has some different laws based on transacting real estate, and not every contract fits the mold for every state. And you need to understand that. So take a little extra time, sit down with a lawyer, and you'll be much more confident when dealing with your sellers that you have a legitimate contract. So number one, do not lie. Number two, review your contract with a lawyer. Number three, this is probably the biggest part that you need to understand to avoid any type of lawsuit in wholesaling real estate. It's perfecting your contract. Let me say it again, perfecting your contract. What do you mean by that? In my 18 years, these are the problems I've had. So you're probably a lot like me. You think quick, you move quick, and we're always trying to find a way to solve people's problems, but we're not as good with the paperwork. You have to fix this part of it. So perfecting your contract is nothing more than simply making sure everything's signed, everything's dated. If it needs to be notarized in your state, make sure you get a notary with at least 2 witnesses. Make sure you have a deposit. I highly recommend doing a minimum of $100 deposit. The $10 deposit creates doubt in your sellers. So get a deposit, and I don't care if you're giving it to a title company, if you're giving it to the seller, make sure you document it. Okay, so if you have a check, take a picture of the check, make sure you have the check number, make sure in the memo pad it says deposit for that house, and make sure your seller knows it. This is going to avoid that awkward, like, I want to get out of the contract thing. So guys, we've done a whole video on that. So this helps you out with that. Make sure you have your inspection dates are clearly noted on there. Okay. Make sure your closing date on or before is noted on there. This is all about perfecting your contract. Say a property goes south and there's a potential lawsuit on either side. It's always going to come down to your paperwork. And the question is, did you take the time to perfect your contract? Did you dot your I's? Did you cross your T's? Did you leave a deposit? Did you get an escrow letter? You know, an escrow letter is nothing more than a piece of paper from your title company says, Rick Ginn left a $100 deposit on this date at this time. And you have that. So why is that important? Because it perfects your contract and shows your true intentions of your ability to follow through on the contract. So after perfect your contract is simply manage your contract. So we're going to manage in particular the contingencies. So once again, inspection dates, closing dates, make sure everything's in writing, and make sure you know how to notify your seller in the event you have to back out of the contract because either you didn't get a buyer or you made a mistake and you overpaid for the property. I've done that before. You'll probably do it too. Is make sure you know exactly how to get out of the contract. So if you put on, say, a 30-day inspection period, make sure how you notify your seller is correct. And by the way, just calling them on the phone is not suffice to cancel a contract. Usually you have to send some sort of documentation. In writing's always the best. I recommend certified mail. It costs you an extra $3 or $4. Just get it done. Send them an email. Make sure it's dated. You print it out. Call them, text them. Just make sure you cover all your bases. So a phone call in most states is not enough to end an inspection period or to get out of it. And make sure you put in there, I had a 30-day inspection period. Today's day 22, And on this date and this time, I'm electing to opt out of the contract due to the inspection. If you would like to contact me to renegotiate the contract, I'd be happy to talk to you, something like that. So past a phone call, past a text. I prefer certified mail. You can write them a regular letter, whatever you want to do. And then I would obviously follow up with an email that is documented as well. But put it in your contract, the way to notify each party. Most parties just have an address on there. Make sure you've got a good mailing address, and that's why it's important to get the email address. We're not going to lie. Fully understand your contract. Review it with your lawyer. Number 3, we talked about this. Probably the most important piece, perfect your contract and make sure you did everything that you indicated on your contract. That is going to protect you in the lawsuit. And then the last one is to manage your contingencies. Make sure you follow through and you understand what dates, the inspection dates, the closing date, everything. If you have any type of contingencies with a financing, which we don't really in wholesaling, so it's no big deal. So let's talk about the last part, which creates the most confusion with wholesalers is we represent ourselves as cash buyers. And let's be honest, a lot of you guys don't have the cash to buy it. If you were like me in the beginning, I did not have the cash to do it. So what you need to do is understand that if you're going to represent and market to your sellers that you're a cash buyer, you need to build your army around you to make sure you can do it. So Rick, what do if I do this? What if I'm not a legit cash buyer and I don't have the money to buy a house for $100,000? That's fine. Real simple. Go out, get a cash partner as a backup. So hey, John, if I find a property and I get it 60, 70 cents on the dollar, are you willing to go in with me? So he can either give you a loan, they can partner up with you, which I recommend in the beginning. They can help you finance it if you cannot assign the contract. You have a plan set, and I'd have it in writing and make sure you have an agreement before you meet with your cash buyer. Remember, you're sending out marketing pieces, either you're texting, you're cold calling, or you're mailing, or you might even be door knocking. You've already represented yourself as a cash buyer, and now you have to back it up. So number 1, find someone you can align yourself if you get caught in a jam to make sure that you can represent your true intentions, which is being a cash buyer. It's just basic 101 business, right? If you're a cash buyer, you're going to be more confident if you know 100% you are a cash buyer. Number 2, go out and talk to some hard money people. So I'm going to warn you, this is not a video on hard money. It's called hard money for a reason. So hard money will, if you set up that relationship ahead of time. So the key with a hard money relationship is to set it up in advance of you going out and wholesaling. So you will know your worst case scenario. The key is knowing their criteria, which they'll fund your deal. So they might tell you they'll fund 70 cents on the dollar and here's their closing fees and interest rates, and you've got to give them 7 to 10 days lead time. Do all the paperwork, let them vet you first, and then they can vet the property when you do it. Then you actually are a legitimate cash buyer. You might have to have a couple $1,000s for the down payment. That's fine. Also set yourself up with your title company. If you haven't worked with a title company, please go ahead and do it at this point. See, you can't be busted for fraud if you've taken the steps to represent yourself as a cash buyer. So last thing in mind, keep in mind, if you ever have to go in front of the court of law, the judge is going to look at basically one thing. And this is my 18 years experience. They're going to look at what your true intentions were. So if you already had a hard money partner lined up, set up, you're working with a title company, you have a cash partner that will back you up and fund your deals, then you can go ahead and confidently assign the contracts with at least 2 contingency plans to cover your butt if it doesn't go through. This is Rick with Flip with Rick, and I'll see you soon.